Welcome, everyone, and thanks for being here today. Today's seminar is about design responsibility and why it's a legal risk, not just a technical one. My name is Rawia Ayache. I'm a principal lawyer at Doyles Construction Lawyers. Design responsibility in construction projects. Whether you're a builder, designer, engineer, or project manager, this affects you. And so today we'll work through both the common law and the new statutory duties in New South Wales. Builders, designers, engineers, and PMs all share exposure. So today's session will examine traditional negligence principles and more recent statutory developments. We'll begin by looking at how the court developed the concept of duty of care before moving into economic loss, design liability, and the impact of the Design, Building and Practitioners Act, or as I refer to it today as the DBPA. So the objective today is not to turn everyone into lawyers, but to help identify the risks and understand where the responsibility might arise. So starting off with a very significant case, Volley and Inglewood Shire Council of the High Court. In this case, an architect was engaged to design and supervise the construction of a community hall. The plans were approved by government authorities. However, a defect in the design resulted from the collapse of a stage and injury to members of the public. The High Court held that architects must exercise a duty of care, skill, and diligence when performing professional services. Approval of plans by another authority does not relieve an architect from responsibility for design errors, and that a duty of care may extend beyond the client to persons who reasonably foresee the suffering of injury as a result of a negligent design. So, Volley is our anchor. Architects must exercise a duty of care, and approval by someone else does not transfer responsibility. It's important to keep the four elements in mind in the bottom right-hand of the slide: duty, breach, damage, and causation. So as I mentioned, Volley remains one of Australia's leading professional negligence cases involving design professionals, where the architect importantly argued that the government authorities had approved the plans. So what was the outcome? The High Court rejected the suggestion that the approval by others relieved the architect of responsibility. And so ultimately what this case demonstrates is that professional responsibility cannot simply be delegated or transferred because another party has reviewed or approved the work. The basics. What is a duty of care? Donahue v. Stevenson. It's a case that involved Mrs. Donahue. She became ill after consuming ginger beer, which allegedly contained a decomposed snail. Although she had no contract with the manufacturer, she commenced proceedings alleging negligence. The House of Lords held that a manufacturer may owe a duty of care to the ultimate consumer of its products. So what Donahue does is that it gives us the foundation of a duty of care, and it shows that a duty of care can arise even where there is no contract through the Lord Aitken neighbour principle. Although Donahue involved a consumer product rather than construction, it remains one of the most influential negligence decisions ever decided. The significance of the case is that it established the modern concept of duty of care and recognised that obligations can arise even where no contract exists between the parties. So how duty of care applies to construction? So in construction, this shows up as design failures, faulty advice, bad certification. But a defect of its own isn't enough. You have to prove duty, breach, causation, and loss. Most negligence claims in construction involved allegations of professional, contractor, or consultant failed to exercise reasonable care in carrying out their work. The existence of a defect alone is not sufficient. A claimant must establish the duty, breach, and causation of loss. So contemporaneous records often become critical evidence in years after the project has been completed. So pure economic loss, why is it treated differently? The courts are cautious about pure economic loss because they are wary of opening the floodgates. Foreseeability alone won't do it. Vulnerability and reliance matter too. The courts have historically been cautious about allowing claims for pure economic loss, and one of the concerns is potential for indeterminate liability. In other words, exposing defendants to an unlimited number of claims from an unlimited number of people. For this reason, courts often look beyond simple foreseeability and examine factors such as vulnerability, reliance, and assumption of responsibility. Understanding economic loss. So what is it? Not all economic loss is the same. Consequential loss flows from physical damage and is usually recoverable. Pure economic loss, things like delay, loss of profit, rent, is treated very differently. Not all economic loss is treated in the same way, and the law generally distinguishes between economic loss flowing from physical damage and pure economic loss that arises independently of physical damage. This distinction becomes important when considering whether a duty of care exists and whether the loss is recoverable. So Hedley Byrne and Co. vs. Heller Partners tells us that negligent advice can create liability where you've assumed responsibility and someone reasonably relies on it. Through here, the disclaimer has defeated the claim. So the facts are, Hedley Byrne relied on a credit reference regarding a prospective client. The advice proved inaccurate and financial loss was suffered. The House of Lords recognised that a duty of care may arise in relation to negligent statements causing pure economic loss. And what they said is it's in appropriate circumstances, a duty of care may arise where one party assumes responsibility and another party relies on that advice. The claim itself failed because of the disclaimer, but the legal principle was established, and that is professionals may incur liability where advice is relied on and responsibility has been assumed. So, what is negligent advice in special relationships? Think about how often you give advice on reports or certifications that others rely on. Where that reliance is foreseeable, liability can follow. Construction professionals regularly provide advice, certifications, reported opinions that others rely upon. Where reliance is foreseeable and responsibility effectively has been assumed, liability may arise if information proves inaccurate and causes loss. This principle remains highly relevant to designers, engineers, and certifiers and consultants. Spartan Steel and Alloys vs. Martin & Co.
Okay, I found this on the web.
In Spartan Steel, the courts allowed the physical damage and consequential loss, but refused economic loss for production. It's the leading case on where recovery stops. So what are the facts? Contractors negligently damaged an electrical cable supply of Howard to Spartan Steel's factory, and as a result, metal in production was damaged, production was interrupted, and Spartan Steel suffered financial loss arising from the shutdown. So the court in this case allowed recovery for the physical damage to property and the consequential economic loss flowing directly from that physical damage. However, the court refused recovery for pure economic loss associated with the production and future profit. This case is important because it clearly distinguishes between physical damage, consequential economic loss, and pure economic loss. Those categories continue to influence how the courts analyse claims today. Economic loss in action. So in practice, repair and consequential costs are usually recoverable, but more remote financial losses often aren't. Not every loss flowing from a defect can be claimed. In construction disputes, parties often assume financial losses will be recoverable. Spartan Steel reminds us that the courts carefully analyse the nature of the loss being claimed and whether the loss flows directly from physical damage or constitutes pure economic loss may significantly affect recoverability. So the nature of the loss remains critical. Pierre versus Pant is another significant case. Pierre shows pure economic loss can be recovered even without physical damage where the claimant is vulnerable. That's key for your design and advice exposure. So what are the facts? A pan supplying infected seed potatoes to a neighbouring farm as a result of quarantine restrictions, here an unrelated third party was unable to export its own potato crop and suffered substantial financial loss, despite suffering no physical damage to its property. The High Court held that pure economic loss may be recoverable in negligence in appropriate circumstances. And in determining whether a duty of care existed, the court considered the factors including foreseeability, vulnerability, and the relationship between the parties. So, what its relevance to construction is that it assists in understanding when courts may recognise a duty of care for economic loss arising from professional advice, defective design, or other construction-related activities. The factors relevant to recovery of pure economic loss. The courts weigh foreseeability, vulnerability, and control, proximity, and reliance. Recovery is never automatic, and vulnerability is often a deciding factor. These factors are not a checklist, but they help explain why some claims succeed while others fail. Vulnerability, particularly, has become influential in the Australian economic loss cases. The courts frequently ask whether a claimant has a practical ability to protect themselves from the loss. So, moving on to the statutory provisions, the most significant change in New South Wales in this space is the Design and Building Practitioners Act, introduced in 2020. So, moving on to the common law, to the statute, Brookfield exposed a real gap in the recovery, and the DBP Act was the fix, headlined by the statutory duty of care. So what the DBPA does is that it supplements the existing common law rights and obligations and provides additional avenue for the recovery of economic loss arising from building defects. So it was introduced as a part of a broader reforms aimed at improving accountability and addressing building defects. One of its most significant features is obviously the statutory duty of care, which is in effect Section 37. So 37 of the DBP Act provides a person who carries out construction work has a duty to exercise reasonable care to avoid economic loss caused by defects in or related to a building for which the work is done and arising from the construction work. So Section 37 is at the heart of it. Anyone carrying out construction work must exercise reasonable care to avoid economic loss from defects. And it runs alongside the common law. This is the key operative provision. Rather than relying solely on the development of the common law duties, as we saw in the cases I just took you through, Parliament has now imposed statutory duty requiring reasonable care to avoid economic loss caused by defects. The focus still remains on reasonable care, but the source of the duty is now statutory. So how the DBPA changed the landscape. Before this, claimants struggled to prove a duty, no contract, later owners, pure economic loss. What Section 37 does is that it gives them a statutory pathway and resets everyone's risk. Before the DBPA, many claims depended entirely on whether the common law duty of care could be established. Now, the legislation doesn't eliminate the common law principles, but it does provide an additional pathway for recovery in appropriate cases. This has significantly altered the risk profile for many participants in the construction industry. And what it does is it represents a shift from reliance solely on the common law to a statutory framework designed to address economic loss arising from defects. So, one of the landmark cases, Brookfield and Multiplex, First Owners Corporation Strata Plan 61288. The facts are Brookfield and Multiplex constructed a service department development. The Owners Corporation later commenced proceedings seeking to recover the costs of rectifying alleged latent defects in the building. The claim was for pure economic loss arising from those defects. The High Court held Brookfield did not owe a duty of care to the owner's corporation in respect of pure economic loss arising from latent defects. And in reaching this conclusion, the court emphasised that the contractual allocation of risk and the circumstances of the particular development. So this case is important because it demonstrates that the limits of the common law recovery prior to the DBPA. It is important to remember that this case was decided before the statutory duty of care was introduced, but this decision helps to explain why legislative reforms were ultimately considered necessary. So some of the key judicial statements made by the High Court judges. Chief Justice French said there was no duty of care in respect of pure economic loss flowing from latent defects. Crennan, Bell and Keane said the absence of a contract between the owner of commercial premises and the person involved in the design and construction of those premises, the latter does not owe a duty of care to the current owner to prevent pure economic loss. So what do these statements mean? The High Court effectively has confirmed that under the common law, a duty of care would not automatically arise simply because building defects resulted in economic loss. The court placed significant weight on contractual risk allocation and the particular circumstances of the development. So listen to Chief Justice French and the joint judgment. Without a contract, there was no duty. So the court leaned heavily on how the contracts allocated risk. So what these two passages do is that they illustrate the High Court's reluctance to impose a duty of care for pure economic loss in the circumstances of the case. And rather, the court focused heavily on the contractual risk allocation and the nature of the development. As I said, this decision remains one of the leading authorities on the limits of common law recovery for building defects. So coming back to the DBPA response to Brookfield, Section 37 was the legislative answer, a new state-based, statute-based avenue for recovering economic loss caused by defects. Again, the DBPA doesn't replace the common law, but it altered the legal landscape significantly. The practical impact is that it reinforces the importance of compliant design, construction practices, appropriate supervision, quality assurance, accurate project documentation, and effective risk management throughout the project lifecycle. So, for industry participants, this reinforces the importance of quality assurance, compliance systems, supervision through the project documentation. So practical takeaways: compliance with standards should be actively verified. Design changes should be documented and approved. Quality assurance processes should be maintained throughout the project. Non-compliance issues should be addressed promptly. And the project records often become critical evidence in defects claims. As a risk management tip, if compliance can't be demonstrated through the project records, it may be difficult to establish that reasonable care was exercised. So practically, verify your compliance documents and approve design changes. Keep your QA running. Fix non-compliance quickly. And if it's not in your records, you can't show that you took reasonable care. So design responsibility. Who may be liable? This responsibility often extends beyond one party depending on the circumstances. And liability may arise from design professionals such as the architects, engineers, building designers, and specialist consultants. What the court asks is who had control, who made the decisions, and who could have prevented the defect. One of the biggest misconceptions in construction is that design responsibility belongs solely to architects and engineers. But modern projects involve multiple parties contributing to the design development, review, and implementation. So when defects arise, courts frequently look beyond contractual titles and focus on what and who actually exercise control and responsibility for the relevant work. So what are the common design responsibility traps? Trap 1, assuming approval removes liability. Approval by a client, certifier, or authority does not necessarily remove professional responsibility. Trap 2. Unclear allocation of design responsibility. Disputes often arise when parties assume someone else is responsible for a design element. Trap 3. Poor documentation. Undocumented design changes often become difficult to justify years later. Trap 4. Inadequate design coordination. Conflicts between architect, structural, and service designs can create significant project risk. And so it's important to watch out for these 5 traps. Assuming approval gives immunity, unclear responsibility, poor documentation, weak coordination, and failing to escalate. Most disputes come from the process, not just the error. So again, when courts examine design defects, they are often looking at the process as much as the technical issue itself. Who made the decision? Who reviewed it? Was the concern raised? Was it documented? Good project governance and record keeping remain some of the strongest risk management tools available to construction professionals. So the practical implications and best practices for design responsibility. Clearly define design responsibility in your contracts. Maintain comprehensive records. Retain design documentation. Implement quality assurance processes. Coordinate consultants effectively and review insurance coverage. So that's the toolkit. Define responsibility in your contracts, keep records, run QA, review your insurance. Many defect disputes are won or lost based on the project records. So good documentation helps demonstrate what decisions were made, why they were made, and who was responsible. And the most effective risk management strategy is often not to avoid mistakes entirely, but to demonstrate that reasonable care was exercised during the project. So what are the key lessons for industry participants? Design responsibility extends beyond designers. Responsibility may arise for any person involved in preparing, reviewing, approving, coordinating, or implementing design decisions. And so compliance remains critical. Compliance with the NCC, the Australian standards, and project requirements remain a key risk management tool. And contemporaneous documents often become critical evidence and defects and negligence claims. The DBPA has changed the landscape, as we've mentioned. Section 37 has expanded potential liability for defects causing economic loss. So to recap the themes, responsibility extends well beyond designers, compliance documentation, and QA is critical. The DBP has widened the liability. As we've seen throughout today's session, the design responsibility is no longer confined to a single consultant or contractor. So the common themes across the cases are accountability, reasonable care, compliance, and documentation. And those principles sit at the heart of both the common law and the statutory framework under the DBPA. So in a decision that is relevant to the DBPA, the Doyles Corporation sought to amend its pleadings, including a claim under Section 37. The builder opposed the amendment, arguing that delay in bringing the claim would cause prejudice, and the Supreme Court permitted the amendment to add the DBP claim. So why does this decision matter? It demonstrates the court's willingness to permit the DBPA claims to proceed when they are properly pleaded and supported by evidence, even where delay is involved. So the key takeaway here is that the DBPA claims continue to be interpreted broadly and may remain available long after projects have been completed. Legal principle. Delay does not necessarily defeat a DBPA claim. A delay in commencing or amending proceedings will not automatically prevent a claim proceeding under the DBPA. So the courts will consider the reason for the delay, whether the claim has a reasonable legal basis, and the interest of justice in the circumstances. Why it matters. Building defect claims often emerge years after practical completion, and project participants should assume that decisions, records, and project documentations may later become relevant in legal proceedings. And this is why it's important to maintain those project records, retain design documentation, preserve inspection records, and ensure key decisions are documented contemporaneously. So delay doesn't automatically defeat the DBP claim. The courts will weigh the reason, the merits, the evidence, and any prejudice. So keep your project records long term. One of the recurring themes in modern DBPA litigation is that claims often arise years after the fact. So while delay remains relevant, the court will focus heavily on whether the claim can still be fairly determined and whether the parties have preserved the evidence necessary to do so. So this reinforces the importance of maintaining those records. Properly pleaded DBPA claims. So under Section 37 of the DBPA, a claim must clearly identify the defect, the relevant construction work, the duty, the loss claimed, and the connection between the alleged breach and the loss. So the courts will closely examine whether a DBPA claim has been properly articulated and supported by evidence. So simply identifying a defect will not necessarily establish liability. For owners, expert evidence remains critical. Defects should be properly investigated and documented. And for builders and consultants, defect allegations should be carefully reviewed. Records demonstrating compliance and design decision-making may be critical. So a DBPA claim has to spell out the defect, the work, the duty, and the loss, as well as the causal link. Simply pointing it to a defect isn't enough. One of the most important themes emerging from the DBPA litigation is that the courts are looking beyond the existence of the defects alone. So, as claimants, they must still establish how the relevant work was defective, why the duty was breached, how the loss was caused. So again, coming back, good project records, expert evidence, and clear documentation remain central to both prosecuting and defending claims. The non-delegable duties under the DBPA. The New South Wales Supreme Court has confirmed the statutory duty imposed by Section 37 now operates as a non-delegable duty. So what does that mean? That means the person who owes a statutory duty cannot avoid responsibility simply because the work was performed by subcontractors, consultants, designers, or other project participants. The duty remains with the person carrying out the construction work. So why does this matter? Modern construction projects often involve multiple parties contributing to the design and construction activities. However, liability under the DBPA may remain with the person who owes the statutory duty, regardless of the contractual arrangements with others. So it's important to be careful in your consultant selection, robust in your supervision and your QA. Contractual indemnities may assist with the recovery between parties, and insurance, critically, insurance arrangements should be reviewed regularly. So what this means is that Section 37 is, in the legal sense, non-delegable. You can't escape it by pointing at your subcontractor or consultant, and supervision and QA are your protection. In practical terms, this means that project participants cannot assume liability disappears because of a consultant, designer, or subcontractor who performed the work. And this has recently been confirmed by the High Court in a decision otherwise known as Pathburn. Moving on to Doyles Constructions versus Warrumbungle Shire Council, a decision of the New South Wales Supreme Court. In this case, the council brought claims arising from alleged defective building work at a retirement village development. In addition to claims against the builder, the council sought to join a builder's managing director and site supervisor as parties to the proceedings under Section 37. The issues were whether the individuals involved in supervising, managing, or controlling the construction work could be regarded as persons owing a statutory duty of care under the DBPA. And the Supreme Court permitted the joiner of the managing director and the site supervisor, and it held that a person within the DBPA was capable of extending beyond the corporate builder to individuals who exercise substantive control over the relevant construction work. So what this case shows is liability can reach individuals, the courts allowing the managing director and the site supervisor to be joined as people who controlled the work. Now, traditionally, many participants assume that liability would solely rest with the contracting party. But what Bolus demonstrates is the courts are willing to look beyond the corporate structure and examine individuals who actually exercise control over the work. And this has significant implications for directors, project managers, site supervisors, and senior personnel involved in construction decision making. So, in its substance, if you exercise real control or supervision, you can owe a duty personally. So, what that means you should do is document your role and your decisions. One of the most important lessons from Bolus is that the courts can and will look at what the person actually did on the project. Simply holding a title isn't enough, but where an individual exercises real control over construction activities, personal exposure may arise. And this reinforces the importance of clear governance, documented decision-making, and appropriate insurance arrangements. Personal liability and project control. Individuals who exercise substantive control over construction work may be joined to the proceedings and exposed to personal liability. So the factors that the court considers is who directed the work, who supervised the work, who make key project decisions, who had authority, and who exercised practical control over the construction process. Why this matters? The existence of a corporate structure will not necessarily prevent the courts from examining the conduct of individuals. And where significant control or supervision is exercised, clear governance and accountability documentation remain critical in managing risk. And the practical response is not to avoid responsibility, but to ensure responsibilities are clearly defined, decisions are documented, and appropriate systems of oversight are maintained. In a decision of Owners Corporation versus LULAC Developments, an Owners Corporation sought to amend its pleadings to include a claim under Section 37 of the DBP Act arising from a number of alleged building defects. The proposed claim relied heavily on defects reports identifying a large number of alleged defects throughout the development. And the court was asked to grapple with whether simply identifying defects was sufficient to establish a breach of statutory duty of care under the DBPA. And what the court did is it refused the amendment. It said listing defects isn't enough. You have to show the risk, the precautions, the breach, and the causation. And what LULAC does, this case, is it's an important reminder that the DBPA is not a shortcut to liability. While the Act creates a duty of care, claimants must still prove that reasonable care was not exercised. And a defect doesn't automatically establish liability. So the courts will continue to require evidence explaining what went wrong, what should have been done differently, and how that failure caused the alleged damage or economic loss. Defects alone don't establish liability. Flowing on from the LULAC case, the defect is only the starting point. Liability turns on whether reasonable care was exercised. So courts judge your conduct, not just the outcome. One of the most important messages from LULAC is that a defect report is not the same thing as proof of liability. So again, the courts will examine the existence of the defect and examine whether reasonable care was exercised. This reinforces the importance of documenting decisions, inspections, reviews, compliance processes throughout the life of the project. The DBPA claims require specific evidence. Claims brought under Section 37 must be supported by clear evidence identifying the alleged breach and resulting loss. The courts expect specifics of the defect, the relevant risk, the precautions, the conduct, and the connection between the said breach and the loss claimed. So, in layman's, they expect what went wrong, why, who was responsible, and what loss followed. General defects claims won't carry the claim. The focus remains on the evidence. Whether prosecuting or defending a claim, the parties must be able to explain what occurred, why it occurred, how the alleged conduct occurred, and how that alleged conduct is said to have caused the loss claimed. Good project records and well-prepared expert evidence remain critical in this process. There it is. Patburn, PTY Ltd and the Owners Corporation Strata Plan 84647, a recent High Court decision. And the facts are, the Owners Corporation commenced proceedings alleging the defects in the construction of a residential development and sought damages under Section 37. The builder argued that liability should be apportioned amongst other parties involved in the project, and that included subcontractors and consultants. The issues were whether the builder could rely upon proportionate liability of the liability provisions of the Civil Liability Act to reduce its exposure under the statutory duty imposed by the DBPA. And the High Court confirmed that claims under Section 37 are not subject to proportionate liability. It found that the statutory duty is non-delegable and cannot be reduced by attributing responsibility to others involved in the project. Patburn is the landmark. Section 37 isn't subject to proportionate liability, so a duty holder can be liable for the whole loss, even where others have contributed. And it's one of the most significant DBPA decisions today. The court has confirmed that the statutory duty created by Section 37 is fundamentally different from many ordinary negligence claims. While builders may still pursue subcontractors separately, they cannot necessarily reduce their liability to claimants by pointing to the involvement of others. This has major implications for project managers, consultant selection, contract drafting, and insurance arrangements. So you can't reduce your liability to the owner by blaming subcontractors or consultants. You will face full exposure. So the contractor selection, QA, and supervision matter more than ever. Historically, many defendants expected liability to be shared amongst those responsible for a defect, but Patburn demonstrates that the DBPA claims often operate differently. So the focus is on the statutory duty itself, and that particular person owing that duty may remain liable to the claimant for the whole of the loss. While separate recovery rights may exist against consultants or subcontractors, that does not necessarily reduce the exposure of the original claimant. This significant change in the New South Wales risk profile of construction projects. So effective project controls and oversight are critical because liability cannot be simply apportioned to others. The DBPA creates a non-delegable duty. Extension. The statutory duty of care, again, is non-delegable. Engaging competent consultants isn't a complete defence. The duty stays with you. The theme running through today is accountability at every stage. And where Patburn confirms one of the most significant features of the DBPA, i.e. that it's non-delegable, in practical terms, this means that engaging the competent consultants, subcontractors is not by itself the complete answer to a defect claim. Those owing a duty must ensure appropriate systems, supervision, and quality assurance processes are in place throughout the project. The consistent theme across these cases that we've discussed today is accountability, and the DBPA reinforces that accountability at every stage. of the design and construction process. So, the final takeaways: managing design responsibility. It requires more than a good design. Successful risk management requires clear allocation of design responsibilities, compliance with applicable standards and regulations, effective coordination between project participants, robust quality assurance and review processes, prompt identification and escalation of defects, comprehensive project documentation, and appropriate insurance and contractual protections. The key themes are responsibility, that is, the court's focus on who exercised control and made decisions; compliance, building standards and statutory obligations remain critical; documentation, good records often become the most important evidence in a dispute; and accountability. The DBPA has expanded potential liability and reinforced personal and organisational responsibility. So the most effective way to manage design responsibility is not after the dispute has arisen, it's through the proactive planning, clear communication, and proper supervision and consistent documentation throughout the life of the project. So let's tie it all together. Responsibility, compliance, documentation, accountability. Manage the risk proactively throughout the project, not just after the dispute lands. Today's cases demonstrate a common theme. Whether we are dealing with Folly, Headley Burn, Brookfield, Bolus, or Pathfirm, the courts have, in those cases, clearly examined who had responsibility, what steps were exercised. The best protection against the future claims is what remains, and that's good project governance, effective communication, compliance with standards, and comprehensive record keeping. By focusing on these fundamental, project participants can significantly reduce their legal risk and ultimately their commercial risk. Thank you all for your time. I'll now conclude the presentation.